joining us today. This is the second in a lifetime series, right, of our Beyond the Closing Table little webinar. Today the focus is on addendums. I have Luke Bacigalupo here with me today. He's our COO, and he's also our lead contracts attorney here in house, and he's going to jump into specifics on addenda or addendums, however you want to do it. And the purpose of these things is just really to expose agents to the stuff that we're seeing, common mistakes or challenges that we're seeing at the closing table that are presenting headaches for agents. And so we're seeing a lot of issues, I guess, probably with addenda these days. So that's what we're going to focus on today. But first, I think it's important, to talk about addenda. And when I say addenda, really, I'm talking about the general addendum that's often used to change terms of the contract. Of course, we all know about the addenda that's provided through GCAR or NBAR and so forth, the standardized addenda. But today we're going to mostly focus on that general addenda, things that need to be changed in the contract. But it's important to understand, I think, before we even get into that, the unauthorized practice of law and what that means. I don't get too worked up about this. There's a lot of chatter out there I read and so forth about agents practicing law and unauthorized practice of law. It mostly is a lot of it's hot air to me, but it is something that you really do need to think about as you're doing a general addenda. The thing to keep in mind is that you're within bounds and you're safe as long as all you're doing is changing terms or altering terms to the contract. When I say terms, I'm talking about the fields that were dealt with, whether it's the the purchase price, the names of the parties, dates on contingencies or dates of settlement, that sort of thing. It's when we get into altering the rights and obligations of the party, the legal rights and obligations of the parties. That's when you can kind of veer into the no-no zone, maybe. Let me just tell you, generally speaking, all three bars, DC bar, Maryland bar, Virginia bar, they generally define, what constitutes unauthorized practice of law, and that's drafting custom legal documents, like contracts or addenda outside the scope of pre-approved real estate forms, or offering legal interpretations or advice, such as interpreting, the enforceability of contract clauses, or negotiating legal terms that require specialized legal knowledge. That's generally what you extract from the area bars, DC, Maryland, and Virginia. We on a weekly basis, we're presented with issues. Agents have issues with certain matters that probably do veer into this area of altering the rights and obligations of the parties, and so we do assist with drafting contract addenda. I'll give you one example. Recently, I think I mentioned this on the last webinar. We currently have a contract in the works where the seller, and if believe this or not, has 31 liens or encumbrances on the property. So what that presented to the parties, or to the buyer particularly, who was concerned that, I want to close within a certain period of time. I don't want to have my deposit held hostage. I want to be able to have a clear path to getting my deposit back when the time comes, if I want to void the contract and so forth. The seller needed more time than what's provided in the form contract. The form contract, provides essentially, it's very loosely it's subjective, it's loosely worded. I don't like it, never have. Although I shouldn't criticize because I don't serve on the contracts committee, so I got to be careful what I say. But the fact is that language in paragraph, it's actually paragraph 16. I think this addenda that we wrote reference 17. That was a different contract, but anyway, gives 30 days, and it really leaves it up to the 30 days for title defects, to cure title defects. And that really, is obviously not enough time in this situation I just described. I mean, we have 31, including a bankruptcy by one of the parties. So it's going to take a lot of time. So we decided to modify the contract, and this is a heavy lift for altering the terms and or not the terms, but rather the rights and obligations of the parties, where we modified the contract such that we're giving the seller additional 90 days. We're giving the seller up to 90 days to get things in order, get the title cured, right? The buyer, again, wanted a clear path to getting their deposit back. So we drafted it in such a way that we made it at the buyer's sole discretion, that the buyer can declare the contract void at any time up to 90 days. If the buyer sees that we're not going to make it, and it's going to delay the buyer too long, they can simply declare the contract void. They can then have a clear path to getting their deposit returned to them. And you'll see the language that we drafted here. The boilerplate language for voiding the contract in the GCAR contract, again, I don't like that either. So we amended that as well. The boilerplate contract simply says that the contract becomes void and of no further force and effect. Without default by either party, both parties will immediately execute a release directing the deposit to be refunded to the buyer, et cetera, et cetera. Well, we all know, and if you've been in this situation, I pray you have not, but there are times when one party refuses to execute a release. Now the deposit's held up. Now we're faced as a title company with the only option is to send it to the court, to interplead the funds into a court and let them fight over it. You don't want that. So we drafted language to make it very clear what happens with the money, the deposit, and that it's completely at the sole discretion of the buyer. So the parties agreed upon that. Anyway, I point this out because this is a perfect example of what you don't want to do as an agent, because that will very likely put you in harm's way with the bar. So give us a call. We can help you out with these sort of things. So I point that out. But anyway, again, I don't make a big deal of this, unauthorized practice of law chatter that's out there now. But it is something you do need to understand, I think, before you go further in executing addenda or preparing or drafting addenda. So anyway, I'll with that opening, I'm going to turn it over to Luke here, and he's going to get into the details of some of the addenda that we're seeing and what we should be seeing and not seeing. So, Luke, I'm going to turn it. Yeah.
Perfect. Thank you. Oh,
I slipped that
did you
in.
get into the
I
you
slipped
got
that
into
in.
the presentation this morning,
I slipped that in on you last night, brother.
Oh, of course, of course. All right. Hold on.
There you
All
are.
right. So I'm Luke. I'm a settlement attorney here at Federal Title. I've been here almost a decade now, so I think I've seen my fair share of mishaps as far as it comes to the addendums. Seen my fair share of great language in addendums and certainly a lot of language that could have been better, we'll put it that way. So I'll get into it here, kind of with the overview. Really, the biggest things here when crafting addendums is use the proper forms and draft clear addendums. So I know this sounds unbelievable to say, for many of you to say, of course, if we have a GCAR contract, we're going to use the GCAR forms. Well, unfortunately, on our end, that's not always the case, and it happens more often than not, where it may be a GCAR form contract with a MAR addendum, something like that, and really that is creating legal liability. So those forms have conflicting terms, jurisdictional language that is for either Maryland, Virginia, DC. And when you start mixing those, you're creating basically legal inconsistencies and contradictory language that is not going to serve anyone well. For example, time periods, just as simple as that, in the different contracts are usually there's a standard time period, say for addenda or for contingencies, things like that, that may change between the different jurisdictions. So if you're mixing forms here, you're running a risk of contradictory time periods as well to get things completed. As far as drafting clear addendums, that's the biggest thing, and I'll touch more on that in a second here. But here you can see some simple free-form addendums. Obviously, you're all versed with things like changing names, extending settlement dates, just those more simple addendums. So where we're concerned here mostly is going to be when you start getting into the more complex, and then I'll also point out some specific addendums that are pretty commonly used that may have some language in them that you weren't aware was there. So we'll get here, proper forms, just went over that. So an addendum should always be incorporated into your contract. So obviously that means you're making it part of the existing sales agreement. So you should always reference the contract that was made on the date it was ratified. Typically, you'll want to go in there and put in the property address. And I know many of the standard forms have that, but make sure you're doing that because we want to incorporate it into the most recent agreement. Also, clear language signed by all parties. And then that last part there, state all other terms and conditions remain the same, or all other terms and conditions remain in full force and effect. Either one is fine there. Basically, we're amending solely one specific part of the contract or adding on one specific provision to the contract, not changing anything else here. So clarity in drafting is huge. And I think especially as an attorney and we think constantly, oh, this needs to be more lawyerly language or something like that. I don't think that's the case, and I'm glad I went to law school only a few years ago. Recent enough where we've gotten away from the here within and therewithals and all of the rest of the lawyerly over the top language, and we've started to work in a more concise and clear way for in just lay terminology. So we often see addendums that are kind of overwritten, where you're writing maybe more than you need to, or using words that aren't as clear as they should be. Clear and concise language is just the best thing to do. And then you should never leave addendums open to interpretation. So this is one of the biggest problems that we see when it comes to general addendums. For my example here, right? So seller to repair a leaking toilet in the bathroom. The thought is, right? All of us are pretty normal people that would expect if there's a leaking toilet in the bathroom that a licensed plumber would come out to go ahead and fix the leak and then notify the buyer that it's been repaired. Unfortunately, not everyone thinks like that. And so you do need to be very concise here. So the better wording for what you're trying to say there would be something to the effect of what I've written. So buyer and seller agree that a licensed plumber will repair the toilet in the first floor bathroom at seller's expense. If the toilet is not repaired by settlement, seller will credit the buyer for the cost of the repair at closing. So you really need to make that clear. We've had a contract here recently where a similar situation to this happened, a contractor was intended to come out. That was the intended meaning of what was written in the addendum. The seller, though, had some contractor background and said, well, I fixed it, right? Well, that wasn't the intent of the addendum. So you should be very intentional with your words, very specific on what you're writing there. And then if the intention is, if it's not rectified properly through a contractor fixing something or however the remedy may be, the intention later on is that the buyer is then entitled to funds or something like that to cover the cost of whatever needed to be remedied. Make that explicit from the onset because all that's going to lead to is down the line another addendum asking for that payment, and it's going to be close, probably closer to settlement, and it's going to be contentious. So it's easier, just get it out in the beginning here. That way it's understood that if the remedy that you're seeking isn't occurring, that there is an additional remedy to follow. So as far as addendums about voidability, so obviously a lot of these are very familiar. You're very familiar with the language, the timelines. So the home inspection contingency, condo resale disclosure. Obviously, the buyer has that portion to review the condo docs and then go ahead and void. Um, Property owners association financing, appraisal contingencies, lead paint, solar panel disclosure. So most of those pretty standard language. We will get into contingencies in more detail at our next meeting. But there is one addendum that I do like to point out that it is becoming more and more and more prevalent as green energy starts taking over a bit here. So the solar panel disclosure is extremely easy for a buyer to void. And typically, for the most part, on solar panel on contracts that include solar panel disclosures, you're not getting a condo resale disclosure or anything like that. It's not going to be the same property type here for the most part. Typically, you're dealing with a single family. Every now and again, you're going to have maybe an HOA that the buyer can void, but the solar panel here is very interesting. So you'll see here at the bottom of the solar panel GCAR addendum here. So the right to cancel. So notwithstanding the solar panel contingency herein, buyer shall have the right for a period of 7 days from the date of ratification to declare this contract void by delivering notice thereof to the seller. So if you have a contract where the solar panel addendum is included, I mean, we're talking about a very vague and a very broad right to go ahead and terminate the contract here. So I know the same claim can be made maybe under condo docs where a buyer can just say, well, the condo docs aren't sufficient, so I'm voiding the contract. But even here with the solar panel disclosure, it is even more broad than that. So it's always something to look at when you do have a property that does have solar panels, especially on the listing side here, that is always an option here for the buyer to just go ahead and claim they're not satisfied and to void. I do want to touch briefly. So Todd talked about unauthorized practice of law, and it is not prevalent, and it's not, frankly. But there are instances, and we do like to point out there when you do get into the portion of drafting, kind of redrafting the contract, you are kind of exposing yourself a bit. So I pulled up two cases here. The first is on the kind of more mundane end, and it was actually surprising to see that this resulted in legal liability for the realtor. But a real estate agent drafted an addendum that included a provision regarding property repairs. The agent assured the buyers that the repairs would be completed, but failed to confirm this with the seller. The repairs weren't done, and the buyer sued. So the outcome here, the court found that the agent overstepped their role by drafting contract terms that should have been handled by an attorney. The agent was held liable for unauthorized practice of law and negligent misrepresentation. So this one seems pretty mundane. It seems like something that we typically would handle, draft the addendum, XYZ will be repaired by settlement. Just keep in mind if you start really assigning terms in that addendum, time periods, things like this, and guarantees to the buyer here in particular, you may find yourself in a bit of trouble. So obviously, if you're going to draft an addendum, follow through and make sure that everything that was encapsulated in the addendum was done by closing, since in the end, it is a part of of a binding contract here. The second case, a little more on the extreme end here. So, a real estate agent added an addendum stating that a property could be used for commercial purposes. However, the zoning laws prohibited such use. So, the buyer is going to rely on that representation and was later sued when the business was shut down. So, the court here ruled again the agent misrepresented the property's zoning status and was liable for the damages. So that's the other thing there. If you're ever not sure about a addendum or you're not sure about use of a property or anything kind of above and beyond your knowledge, reach out to an attorney, reach out to one of us, and we'll research it. That way, you're starting in the right position and moving forward from there, and not taking a gamble on the underlying issue around the addendum. Give me one sec here. I see a couple. Oh, I see Todd. You're in the chat there. Perfect. All right, next I'm going to go here to common mistakes we see. So I know a lot of my spiel here has brought up the hypothetical addendums with repairs. A lot of agents, I'm sure you are victims of this. You put together a great addendum, you have a repair that needs to be done by settlement, everyone agrees to it, and then the lender comes back and says, a general addendum cannot specifically reference that a credit is for repairs. So keep that in mind. This is going to be the case about 90% of the time. So you can say something like seller credits buyer $1,500 at settlement. That's it. Even if the $1,500 or so is for the repair. So leave the repair portion out of it if you do have a lender. It's just the better way to go. $1,500. That's it. And then if you want a kind of supplemental agreement that it's about the repairs, that's something that we can handle for you and put that together and have signed by all parties. That way it's everyone's understanding that the repair will be done with that money. But the actual general addendum to the contract should just state very simply what the amount is being credited to the buyer. Rent back agreements. So this is a very interesting one right now. So rent back agreements at one point did have language in all jurisdictions that DC, Maryland, and Virginia here that early vacation by the seller here would allow for a daily prorated amount to be refunded. So that is no longer the case on the G-Car contract. So if the seller does vacate the property early, they are not entitled to any of the prepaid money up front. So let's say you wrote the contract here. It's going to be from the 1st through the 31st at $1,000 for the entire period. If the seller moves out on the 15th, they're not entitled to any of that money back unless the general addendum is done to the contract. The only jurisdiction right now that still does show language to go ahead and get for the seller to claim a refund if they vacate early is the NVAR contract. So that will still have an option for you to select whether it can be reimbursed. So that's one to look out for here. The remedy for that on the rent back agreements is to go ahead and put together a general addendum that is supplemental to the contract here that just states seller may vacate at X date if seller vacates prior to the expiration of the rent back. They're entitled to a prorated amount per day, that kind of language generally. The title company choice is a big one as well. Title company choice is a notice provision. So a notice provision meaning it does not require an addendum. So the buyer legally in DC, Maryland, and Virginia, so the 3 jurisdictions we work in, has a statutory right to select the title company. So it's simply a notice provision there. It can be done unilaterally. It's not something where the buyer and the seller need to agree on a separate addendum to have that changed. I do have a copy here. So here's the G-Car rent back as what I was just talking about here. So at the bottom there, you can see the amount paid for this license is non-refundable in the event seller vacates the property prior to the end of the occupancy period. So this is this is somewhere here where you could go ahead and do kind of a general addendum. That way, your seller, if they know they're going or they may vacate early, they can get some money back in the event that they do so. And then just kind of the general takeaways here. So if a transaction requires a custom addendum, reach out to us. We'll draft it. Perfect example here, seller financing arrangements. So obviously with rates being where they are, these have become a little more prevalent where the buyer is using seller financing. If there is some sort of arrangement that wants to be made there and you want to incorporate it into the contract, go ahead, reach out to us. We'll spit out a good addendum for you there to put into the contract. That way, you're not just using boilerplate language that may not cover the situation here. And then if you're altering existing legal language in standard forms, it should be done cautiously, as Todd was saying as well. So for the most part, you're covered under basically all of the general terms of a GCAR agreement. But if you do find yourself crossing a lot of language, then it's time to kind of step back and say it's better if I'm not the one handling this. All right, Todd, I'll let you jump back in here.
Yeah.
Actually, hold on. I'll share again. All right, go ahead.
All right. Well, that's good stuff. We had a couple of questions. I think one of the questions was whether there's a NVAR solar panel addendum, and there is. I think the other question was on the closing cost, the cost of a repair. Should the cost be in there? You know, the actual. Well, oftentimes you don't know what the cost is at that point in time. So just if you do, obviously put it in there, estimated cost. But if you don't, of course, it's sufficient to just say that the seller is obligated to bear the cost, and which can be determined prior to closing or at the time of closing. So, anyway, good questions, and we'll just wrap it up here. But here's a little, I guess, a little promo here for our Close It app. So we are soon to make this completely free and available to everyone. This will happen April 1st. And so we'll send out a notice to everybody that the Close It app is available for free use. And it's if you haven't tried it, try it. We have about 3,000 agents currently using it in DC, Maryland, and Virginia, and it's about as accurate as you can get in terms of calculating the buyer's cash to close or the seller's net proceeds. So, and we're constantly making improvements to it. So, give it a try. And then I want to tell you that our next meeting will be April 1st. And yes, that is April Fool's Day. And Luke, no, I won't slip in a picture of your child. I promise. And so April 1st is our next. It's always the first Tuesday of every month, and we'll be talking about contingencies, navigating contingencies, which can cause a lot of confusion and gets people tripped up. So we're going to talk about that. So anyway, thank you all for joining us, and we hope to see you at the closing table soon.
Yeah, the one other thing I'll state here real quick. If you do have any other questions, obviously reach out to us. The point of these sessions is to just pack in 30 minutes, keep you entertained for 30 minutes and not drag it out all day. So if you have questions, please email me or Todd, and we'll go back and kind of answer everything more thoroughly and in depth.
Great. Thank you.